Okay, we are recording now. It is time to get started with the lecture. This is week four already. We only got 7 more weeks to go after this, and we only got 3 more lectures to go after this, week 6, week 8, and week 10. So time is moving on. And so I am going to go ahead and I'm going to get right into our lecture. Be sure to audio. Okay, good. All right. Okay, so we're going to go ahead and we're going to get started. So let me get right into our assignments. We got 2 sections to cover tonight. We're going to cover as much as possible. We're going to end either 10 o'clock or pretty close to 10 o'clock. So let's go over. There are several things in the lectures that involve your assignments for the week that you might want to be brought up to speed on. So let's see. Let's get right into sharing my screen. Okay. So just a little note for you that just was released on yesterday, letting us know that on this Thursday, the 26th, from 5 a.m. to 8 a.m. Central, so that means for 6 a.m. to 9 a.m. Central for you guys on the East Coast, that your Blackboard you'll not have access to. So you want to make sure that you get your assignments in before that. So that's just a little note that they just put in to us. And again, I remind you of my information. Again, I encourage students again, and I say this over and over again during the quarter. I mean it. Feel free to email me, text me, or phone me any hour of the day except the 25th hour. That means you can call me tonight, late tonight, early in the morning, and sometimes I'll answer and sometimes I won't. Most of the time, I will be right here on my computer working because I work late at night a lot of times because I work primarily from home. So just be sure. And then I also want to remind you that in all your papers, you are required to conduct research. That means that the sole source cannot be the textbook. You'll lose 2 points. That's in addition to what's in the syllabus. So some of you have seen that, and I had one student say, oh, I didn't know about that. I said it's on your course page. It's also in the syllabus as well. And then, of course, APA format means citations in the body and references. Sometimes students give one or the other. So, and then reminding you that our next lecture will be in week number 6 coming up. Okay, so let's look at what our announcement says for week 4. And I always remind students to make sure that you look at the announcements and the calendars, which we're going to go over for clarity, for anything you have a question about assignments. And then look at the assignment itself and then your rubric that I gave you that tells you. Now, 4th week, we're talking about crimes against people and property. And 7 and 8, I sent you already the PowerPoints for that. And the additional material, you should have that as well, which is kind of an outline of the chapters. And then the activity crimes against people and property, we'll take a look at that as well. Okay? And then your Discussion assignment, robbery, burglary, and theft. We'll be talking about that during the course of tonight. So that is due tonight by 11:59 p.m. Central Standard Time for your initial post. And as I said before, and I keep saying again, your post should be detailed. You can have citations and references. That's great. But the key thing is don't just say, yes, good post, nice post, or I enjoyed your post. That's not going to be adequate, and you're going to lose points. And please recognize the fact that you must get your post in on time to maximize your points. In this class, you get 5 for the initial post and 5 for the reply post. And then your reply post is due by Saturday, 11:59 p.m. Central Standard Time. And you should be aware of the fact that those assignments after Sunday, for that week, I don't care how good your posts are, I cannot accept them. They have to be in the week of the discussion forum. Finally, you have one written assignment, rape shield laws, and the quiz. Now, be aware that in weeks 1 and week 3, you had a written assignment and a project. From weeks 4 all the way to week 8, you will have one written assignment and the quiz, and then your discussion post. So it's important that you get these in on time and that you satisfy the pagination, 2 pages as required with citations, references, a cover sheet, and then make sure you run your papers through Grammarly to make sure that you don't get hit with a Grammarly hit, because if you, for example, have 50% that comes up on Grammarly, you'll lose half your grade, which means you'd end up with a 10. And so you don't want that to happen. And so anyway, rape shield laws is what we're dealing with. So when you get to week 8, 9, 10, and 11, those last 4 weeks, you will have 2 written assignments or your project. So for now, you are done. Now, this week, please take time to complete the mid-quarter student surveys. I appreciate the comments. One student has already made a comment that there are too many assignments, written assignments for the week, and I had to reply back to that student that that is not within my control. I teach the class. I can give you opportunities sometimes, depending upon what I feel is fair as far as extenuating circumstances, so that you don't get dinged for late points, and opportunities to catch up based upon extenuating circumstances. But I cannot take away the assignments that are given each week. Those are the school requirements, and I will enforce those requirements in every class that I teach. Sometimes they give us some leeway in terms of it, but this is one of the classes that is kind of like right, as we say, right down my alley. This would be an eagle in golf, or a strike in bowling, a 300 game. When you're talking about criminal law, I was a criminal lawyer for many, many years, and so this is really a course that I try to make easy for you. There's a lot of terminology, and while I'm speaking about that, I do recommend that when you're doing the quiz, that you try to do the quiz at the end of the week. Your assignment, you know, are due. Your written assignments are due on Sundays, and you know that they're due by 11:59 p.m. So I recommend that you go through your quiz, your material, become familiar with the material, look at the outline material I gave you, listen to the archive. If you haven't participated in the live lecture, as I see tonight, I just have Eric with me. It's unfortunate that many students don't take the time to come, because as soon as they hear the word "is not required," they don't want to do it. But personally, the way that I was able to excel while working a full-time job, while raising kids, working 40 hours a week, while not having a car, not having laptops and all that, because we didn't have it at that time, is that if there was something extra, trust me, I was going to try to figure out a way to get to it. We didn't have recordings, so we had to get there. And work was not something that I ran away from, and as a result, I became very successful. Got into a good law school, practiced successfully with my criminal cases. Now, finish strong. That's what I want you to do. Don't just, drag through. Come on, let's do this thing. I try to get the grades out as quickly as possible. I've been doing pretty good this quarter. All your grades are in for weeks 1 and week 2. I've already started working on week 3. They're due by the end of this week, or I usually have them by Sunday completed for that following week. So you'll see those as well. Of course, your quiz, they automatically go in. And so back to the quiz again, I feel that I have to keep saying this, is that you have 1 minute per question. And if you actually have gone through the material, studied it, and familiar with some of the terms in there, you'll be able to. But remember, with multiple choice exams, there's always 2 answers that don't fit at all, and then there's maybe 2 that are close, and then sometimes, as I try to explain to students, if you know there are 2 answers in there that are both correct, and you don't see one of the sections that say A and B, for example, or tying 2 together, then it's going to be all of the above at every instance because of that fact. That's the rule of multiple choice exams. So anyway, so let's do this. I know you're going to have adversity. I told you about mine. I told you about some of the things that led me to it, but also I had adversity while trying to get through school. But it took me 7 years of college and 3 years, so 10 years it took me to get my law degree. But it was okay. I got it, and I was happy. So now let's do this. Let's do this, okay? Let's work together and let's communicate. Now, let's go to the course calendar again. Sorry about that ding there. Oh no, I keep hitting that thing there. Okay, let's look at the course calendar again. Here we are, down here at the bottom. There we go. We're at this week, which is week number 4, and it shows you your initial post, your reply post, when they're due. Some students sometimes, I just look at the announcement, look at the calendar. Then talks about your mid-quarter survey, which I encourage you to take. I do read those, and they tell me a lot. And then the written assignment is in there when that's due, and then your quiz, and then the following week. And every week you will find what you need to know in your in your calendar. Again, just to confirm what I was telling you, let's just look ahead. By the time we get down to February 26th, the week before February 26th, the week of the 20th, that's week 8, then you'll see there's a project there. There's a project there, and then when you look into March, you'll see the same thing. Okay, so there we go. Here it is, March, and then the last one will be due the last day of the month. Course, which is the 17th, which is we don't get to that because it's going to be on a Friday, and not that you'll have that whole weekend there. All right, so now let's go right to the module. Our lesson, let's go to assignments first. Okay. I don't know why this does this all the time. And whenever I'm in this particular mode, let me see if I can get it up. There we go. So you get 20 points, And then here is the assignment. And it tells you what you have to do. And you want to make sure that you follow the answers. It's a 2 to 3 page paper. Remember what I told you, the requirement. Also make sure you discuss what in camera is, because I'll be looking for that, because that's part of the 3 bullet points that they want you to answer there. So you're going to make sure you answer every question. 20 possible points is what you can get, and double space submissions with citations and references as well. Okay, let's go back to seeing the discussion. So you already know what the discussion is. This is one that tricks a lot of students, but I'm actually going to talk about it tonight, so you'll have an advantage. There are a few students already that I've looked at today, some of your posts, and some of you got tricked a little bit into some of these charges. So anyway, we'll talk about that in a minute. And then, of course, your quiz. So now let's go back. Let's go back to the actual lesson content. So the lesson content, of course, always gives you an objective. We're going to define crimes against people, property, and identify the degrees of theft. We'll talk about that in just a minute. Of course, there are your assignments again. We just went over those. And then I'm going to have you to go over and make sure that you look at these. This explains what assault and battery is, what rape and sexual battery is, larceny. You won't really see the term larceny too much anymore because we usually use the term theft in place of larceny now. But it is the same thing. It is the same thing. False pretenses. We won't deal a whole lot with that. And then burglary versus robbery. Both burglary and robbery are described interchangeably, but it's important to understand that there are 2 different crimes. It says here, today burglary is defined as breaking and entering the dwelling of another with the intent to commit a crime or larceny therein. And at common law, I remember we were in law school, this was one of the neat things we talked about, as burglary was limited to homes and nighttime. So we used to always state it as breaking and entering the dwelling of another with intent to commit a crime or larceny in the nighttime. Of course, so now burglary is 24/7, and that nighttime has changed. Now, the reason why it was like that, just a little history for you, because I like people to understand things, is that burglary, as I said, would happen at night because that's the most vulnerable time that people were. Most people were sleeping at night. And so as a result, that was and we're very vulnerable. So that was why burglary included the nighttime requirement. During the day, people were often gone or they were up and alert. And then also, when criminals committed burglary, they would, oftentimes burglars are known as wearing black because it would blend in with the nighttime. So, but that requirement is gone. And so anyway, we're going to talk about little twists to burglary tonight when we get into the lecture. Today, a burglary can occur in somebody's house and in their vehicle, in their business, or vessel at any time of the day. Say, okay. And then robbery is defined as unlawful taking of personal property of another with the intent to permanently deprive that person. However, though, it has 2 other elements. The taking must be from the person or in the person's presence. Now, it's debatable about what in the presence means, but it's arguable that the context of from the person and in the presence of the person should be considered contextually. That let's say, for example, I'm in this room here and somebody comes and they take something and by force from me in this house. and it's sitting on my table, then that's probably going to be, well, that'll be burglary. But anyway, let's just go with the robbery thing. Let's do it outside instead. So we're outside, and then somebody takes something, and it's in my vicinity where I'm at right there. Then that might be considered robbery. And of course, if it comes directly from me by the use of force, intimidation, of course, if they don't take it, if they take it not from me but in my presence and use force or intimidation or a threat of violence, you're either going to give me that, or either I'm going to blow your head off, or those kind of things, or I'm going to hurt somebody in your family, then that would be robbery. So then we have these different things in here, and I always encourage you to go through and do these. I'm going to do this like 2 or 3. The unlawful use of force by one person against another that entailed some injury or offensive touching. What is that? Eric, can you have a shot at which one of these that is? The unlawful use of force, the first one that I'm pointing to. Which of these words apply? Type it in. Have an idea? Okay, I don't see anything, so this is what it is. The willful and malicious destruction of any real or personal property belonging to another person. The willful and malicious destruction. That's what that is. You might not have got that. Some people don't know that one. The breaking and entering of a dwelling of another with intent to commit a crime, therein including but not intended to theft, while someone is present someone is present within the dwelling. Some people would think that's burglary. But the reason why it's home invasion is because you don't have to be present in order for it to be burglary. Here we go. Whether it's occupied or not, here we go there. That would be breaking and entering a vehicle, conveyance, so forth, so on, with the intent to commit a crime, whether it's occupied or not at that time. So anyway, those are just a few that you do. So I encourage you to do those things, okay? So now, any questions about any of the assignments, Eric? Oh, okay, you had battery. Some reason that I didn't see it in the thing there. So, okay, so you don't have any questions. All right, so now let's get going here. So we got quite a few to go here. Let's look at Chapter 7, offenses against persons. Now remember, this is when you think about what I'm about to say. When you start the law, think about it in terms of criminal laws. The most serious offenses involve dealing with people. Later on, the next chapter is dealing with property. But people, because life is more important. You can replace things, but you can't replace people in terms of that. So that's the reason for that. So let's delve right into it. Assaultive defenses. Crimes against persons, typically a state rather than a federal offense. Assault and battery were misdemeanors under common law. Now, assault is different from battery. Assault means, for example, putting someone in fear of being struck or hit, such as raising your hand to them and they're in your proximity, or threatening to throw something at them. Battery is actually not only raising it, but then making contact, like I hit myself. Of course, that's not battery, but you know what I mean. If you hit me or someone else were to hit me or touch me, it's an unwanted touch. You'll see that in a few minutes. But they were misdemeanors at common law, and the reason was because there was no real serious injury to people. You'll discover that in misdemeanors, these are crimes that are not as serious on against individuals or property as felonies. And I have stated before, and I'll state again in respect of time here, that the difference between the two is a misdemeanor is based upon the sentence. If the sentence is up to a year, then it's a misdemeanor. If it goes to a year and above, then it's a felony. And so that's the difference. And think about the possible sentence increases based upon the seriousness of the offense. Assault and battery of public officers, though, are considered as felonies, but that should make sense to you because we don't want people attacking public officers. Now, public officers doesn't necessarily just mean police officers. Public officers could be attacking people who are delivery people, also individuals who are working for the utility companies, cable companies, people who provide services, and particularly if they work like for the municipality, of course, you know, firefighters, of course, would make sense, EMTs and other people like that. But these are felonies because of the fact that you're stopping them from performing a service that is good for the public. Aggravated assault and aggravated battery are also felonies. Now, the difference in simple assault is, like I said, if for example, okay, now I have picked up this calculator. Now, this calculator is not really that heavy, but if I pick this calculator up and threaten to hit you with it, or let me use an example that I like to use, a bat. If I had a bat in my hand and I, you know, took the bat, then it might be considered as aggravated assault. On the other hand, if I took this pen, that's not going to be as serious. It could be argued that that's not necessarily aggravated. But aggravated, you think of it in terms of increasing the possible reason why that person would be in danger. And then, of course, the battery, aggravated battery, is, of course, carrying through with that and actually making contact with that person. Also, you'll discover that aggravated battery involves using caustic solutions such as acid or hot water or something that would damage or hurt that person as well. Okay. So assault does not require physical contact. Shooting in the direction of a person, now that would probably be aggravated because of the weapon. Threatening someone with a weapon, that would be probably aggravated. And so when you get to the aggravating factors are where deadly weapons are involved, i.e. a gun or threatening somebody with a weapon or great bodily harm, as I was telling you about the caustic solutions, for example, even if you don't pour it. Then the battery requires actually physical contact, hitting, offensive touching, using excessive force to break up a fight, intentionally tripping another person, using excessive force in disciplining your child also could be considered as battery. Great bodily harm, as they say, it's no real consensus. However, let's look at this one. At one point, does spanking a child become child abuse? California has a law that child abuse is the willful infliction of a cruel or inhumane corporal punishment. I think the key words, infliction of cruel or inhumane punishment, or an injury that results in a traumatic condition. In this case, this 4-year-old threw breakfast at his mom because he was unhappy that they weren't going to Disneyland. Well, the mother put the kid in timeout, but the kid continued to act up, hitting his mom, spitting on her, and the mom wants to give him a spanking on his butt, but she misses and hits his head. Instead, Timmy falls over and hits his head on the floor. The doctor diagnoses a concussion. Now, did the mom inflict great bodily harm on this child? Do you think so, Eric? Yes or no? What do you think? No? No, she did not, in my opinion. And one of the key words here is willful infliction. Willful. She was trying to strike him on the butt, but missed. So, so it has to be tied together. It can't be just picked. Oh, it resulted in probably a traumatic condition or an injury, but it wasn't her intention to do so. So you begin to apply some common sense in terms of understanding how these things apply. If you don't have common sense, then you got a problem. Prosecutions and defenses. Simple battery, simple assault and battery. Prosecutors typically just have to prove that the act and general, not specific intent. Aggravated, prosecutors have to prove specific intent. So in other words, the specifics must be that that person in dealing with the aggravated assault must intend to do great bodily harm or commit a felony. So let's say, for example, is, I ought to hit you with this. I ought to hit you with this thing here. So again, you can see I'm holding this thing up. Just me talking about it, that doesn't reach that stage. But if I make some gestures, and my language goes with it, and probably my body language, everything gets you in reasonable apprehension of receiving a battery, then you probably will get into that particular possible crime. Some defenses defines the degree of force that can be used by teachers, police, so forth. Teachers generally can't use corporal punishment. Police officers, we already know about excessive force cases, that it was accidental, like in the case of the little boy. Was it what you did reasonable under the circumstances, or were you engaged in self-defense? But remember, the parameters of even of self-defense is that it must be the necessary force to repel or protect an individual. So if a person pulls out a stick and you take out a gun and shoot him, you might have a problem depending upon the total circumstances there. So, mayhem. We don't hear that term anymore. Willfully or maliciously injuring another so as to render that person less able in fighting. It's statutory in most states, and it involves things like disfiguring that person, like what we talked about a few minutes ago. Prosecutors just generally have to prove general hurt. Yeah, I figured not. Because don't worry about it. It's statutorily laid out. Most of the crimes that fell under mayhem, though, are included under aggravated and attempted. So that's why you don't hear that term anymore. One of the things in these lectures that we do is we give you a historical perspective, because the best lawyers, the best people who understand the law understand the history of why something takes place. I've even had to present that to judges sometimes in courts. So, but yeah, mayhem. Every once in a while I look at a comedy movie or a Western or something, and I'll hear the word mayhem. But you're right, you don't really hear that term anymore because it's not really a modern day term. It's now more aggravated murder or attempted murder, so forth. Okay. Hazing. I know you heard that term before. Okay, we didn't hear that term very much when I was younger, but you know what it is. It occurs where people are trying to initiate people into sororities and stuff like that, fraternities, athletic teams. Okay. So you know about that too from the Army as well. And so it involves foolish pranks, but often results in serious injury. Many college universities have prohibited hazing, and in the military, you could get some very serious discipline for hazing a person. Am I correct? Yep. Yes. Yeah. You can. Here's the deal. It's an intentional or reckless physical or mental harassment. In the military, do we want our military people to be mentally tampered with? I don't think so. No, we want you to be on full alert. We want you to be able to operate with a sound mind at all times, and we don't want anything or anybody. But an example of hazing that I'm familiar with is when I was in college. This goes back to, gosh, before you guys, 69 is when I started junior college, and I was at this junior college in Chicago, part of the city colleges of Chicago, and I was at a school called Loop College because it was called Loop because it was in the Loop, which was just what the downtown area is called. At any rate, now the school is called Orientation. Yeah. I'm familiar with that. It's just a synonym. That's all it is. It means the same thing. Yeah. Well, anyway, this thing here that I'm going to talk to you about, hazing, they used to do the same thing. Now, I'm glad you said that. This was in junior college where they had an organization called Wine. The name of the organization was Wine Sci-Fi. In other words, it was literally what I said, wine. It was spelled wine, sci-fi. And that was what it was. So it sounds like a Greek sorority or something, or fraternity or something. But anyway, in this fraternity, what you had to do was you had to drink so much wine in a certain period of time. Well, there were people, and I didn't drink alcohol, so I don't either to this day. But so I never would qualify for it. But I knew people who were involved in that. And so, unfortunately, what happened is that one of the parties who were going through the orientation or hazing that were qualifying them for being a part of this group developed alcohol, I forgot what it's called, something with the brain, where the brain, they had too much alcohol in a period of time, and they went into a coma and never came out and died, and that was the end of that organization. So a lot of these kinds of things, they're ended. But you know what? Today's kids, you're steadily hearing stuff. I mean, it's ridiculous. But anyway, it's illegal. It's illegal because you're messing with the mental state of people. Some examples of hazing, here's a few of them. And this is kind of like what I was talking about, 2 near fatal accidents of alcohol poisoning, which is what I was talking about. Approved a new policy at Harvard. Believe that? Harvard. Can you believe that? Organizational athletic leaders might be held responsible for serious incidents involving hazing or the consumption of alcohol and drugs. And so, it's kind of crazy. It's not kind of, it is crazy. So don't do it. Stalking. This is another modern day term that we didn't hear when I was a kid growing up. Following or placing a person under surveillance and threatening that person with bodily harm, sexual assault, confinement or constraint, or placing that person in reasonable fear of bodily harm, sexual assault, confinement, or restraint. Now, actually, if that person is made to feel uncomfortable and feel that you might try to force them into doing something, it fits within the confines of that. Look at what it says. In 2006, an estimated 3.4 million persons 18 years or older were victims of stalking. We just had a incident that happened here in our vicinity. It happened in Indiana, which is our neighboring state, where a guy broke up with a girl and he was stalking her, and then yesterday he killed her and shot her and some other people as well. So stalking leads to other very serious offenses. In 1990, California was the first state to make it a crime. In our state of Illinois, we have something, and we'll talk about that in a few minutes, about stalking, and I'll hold off on that. But the federal statute was amended as part of the Violence Against Women Act. We're dealing with domestic violence and things of that nature. And during the 90s, many defendants attacked stalking, saying that they violated the First Amendment. They had the right to be and doing what they were doing, but no, because the courts said no. There are no First Amendment rights in making a person feel uncomfortable in those kind of situations. People should be left alone if they don't want to be bothered in those kind of situations. So now we have this new thing. That's what I was going to talk about, cyber stalking, because the wave that came in with the internet and everything, harassing or threatening a person through persistent online contact. That involves texting, that involves FaceTiming, Facebook, Twitter. I don't think LinkedIn. I haven't seen cyber stalking used in LinkedIn too much because it's more used for purposes of business and things like that. Pinterest, which I don't know how it's used in Pinterest. I don't quite get that part because I look at Pinterest, but it's not a big deal for me. I don't use it. I am frequently with Facebook, and I am Twitter. That's another one now. But Illinois has criminalized. It's a felony. It's a felony. And what has happened is that this type of stalking has resulted in bullying, where there have been students who have committed suicide, taken their lives, and things of that nature. So cyber stalking is very, very real, and it is a threatening thing. The federal government, in terms of dealing with this, because you're using interstate commerce when you're dealing with the internet or online situations there, you are engaged in the possibility of the federal government coming in. So many states have amended their statutory definitions of stalking, not only to have the simple stalking we talked about in the previous slide, but now cyber stalking as well. We're in that age. Rape and sexual assault. Forcible rape is, of course, we already know, sexual intercourse by force when that person is against that person's will. Now, statutory rape, on the other hand, is a strict liability offense, having intercourse with a minor, irrespective of the minor's consent. I didn't do a lot of rape cases, but I've heard people, talk about, and then I had training when I was a police officer about statutory rape. The key thing is that child, the number of years that child is. I don't care how, young people today are maturing so fast. Young girls, you're hearing a whole lot of crazy stuff where teachers are finding themselves having sex with students. But hey, it's crazy. You will go to jail for that, and you will be labeled a pedophile, and you will have to register, and you will not be able to get jobs and things of that nature. You will end your living as a person who can progress. You can have all kind of education and degrees, and you will be in big trouble if you do that. But anyway, here's my point, is that it's the minor that's being protected. Somebody said, well, they knew. They're very smart. Man, they tricked me. Famous last words. Well, guess what? Because it's a strict liability offense, it doesn't require knowledge, mens rea, or what we call scienter. Scienter is spelled S-C-I-E-N-T-E-R. S-C-I-E-N-T-E-R. It's no space there. So yeah, it's not required. In other words, you can't use as a defense, I didn't know. or yeah, that kind of thing. And judges are not going to be sympathetic with you in most jurisdictions because it's a strict liability offense, and rightfully so. Rightfully so. Marital exception, the Hales rule remained valid in England until 1991, where a person can be charged as an aider or abettor if he or she assisted or procured another man to rape a wife. Well, that makes sense. But I will tell you this, that there is some debate in many jurisdictions about the issue of can a married person rape their spouse? And the answer is it depends. It depends upon all the circumstances involved. You could be legally separated, or you can actually establish that you have left the premises, and then in that instance. But I would say to you that we don't have a whole lot of those. We don't have a lot of those. I didn't deal with a lot of rape cases. The only real rape case that I ever did was a young man who was charged with rape, and this young lady, she said that he raped her, but she was actually his ex-girlfriend, and she wanted to punish him because he wanted to go back to his wife, and that's what she did. But I didn't even do a jury trial. I did a bench trial with a female judge, and the female judge acquitted this young man with a one-day trial. So it was just so clear what was going on. But I had to have a hard time representing people in rape cases as a defense attorney. I could do murder, I could do all those other kind of things. I couldn't do domestic violence because, if you know my history in terms of what I went through as a child, it would be unfair. But what I was going to say is that rape cases, it would be unfair because I have 8 sisters and no brothers, and I have 6 daughters and 2 sons. So I'm kind of accustomed to being around females and stuff. So it would be unfair, and I've seen some pretty tough situations there. So anyway, it is a strict liability crime when it comes to minors. And then I've already said all of this. You know, consent is irrelevant. And so there's some opposition, because this is what people argue, says out of touch with present-day sexual mores. Hey, listen to me. I'm looking right into the camera when I say this. Sexual mores, what is that? Are you telling me that because there's more sex taking place and that we're at a consensual stage? Yeah, that may be. Consenting adults, people, not consenting minors. We don't have that, and I hope we never reach that stage. Period. And then I'm going to leave that alone. I said period, and it's kind of a new thing to say now, but I'm going to just say it, and everybody almost knows why I said that. Anyway, deprive people in their late teens of exercising. Please. Give me a break. I got a daughter who's 17 years old, okay? And she just turned 17, 7th of this year, 7th of this month, January. And, you know, I don't care who it is. If they do something to her, I'm pressing charges. My wife's pressing charges. And it wouldn't matter anyway, because the law is the law. All they ask is, what was her age at the time of the offense? Well, she appeared to be, I don't want to hear that. She said she was, I don't want to hear that. So she had a fake ID. That's not a defense either. So the point of the matter is you know, that's ridiculous. Deprive women in their late teens. No, we're not having that anyway, especially at my house. And then rape laws now are nutrigender because of the fact that, and then it says criminalizing forcible sex between spouses, and I told you kind of like some of the parameters that's involved. Using foreign objects that person is not interested in having done. Dividing the offense of sexual battery into classifications to degrees. We don't have that here. And then now finally enacting the well-needed rape shield laws. Now, let's talk about that a little bit. You're going to deal with that in one of your assignments here. Statutes that protect the identity of a rape victim and prevents disclosure of victim's sexual history. In prior years, what often has happened is that a victim of rape didn't really want to come forward because not only was it embarrassing, but because it would be humiliating even to go through the process. Because one of the questions that would be often asked by defense attorneys is, have you ever had sex before this, and that kind of stuff. And those kinds of things. How many times have you had sex? Have you had sex more than once, and so forth and so on? Did you enjoy it? And that kind of, it was some crazy stuff. Like I said, I didn't do them, but I used to sit and hear them. Well, the law finally got smart and said, whoa, we are punishing the victims more than the criminal, the person who commits the offense, and therefore people aren't going to come forward. And also the fact that individuals, a lot of their personal life would come out in terms of that as well. So now the rape shield laws have come about to protect the identity of the victim and then not allow you to go into the previous sexual history of an individual. And it should be limited to the incidents of the case that is present before the court. Also, to protect that, they have what we call in-camera hearings. And in-camera hearings involve where the judge and the attorneys out of the hearing of jurors or the public in privacy discuss the issues there about what takes place. And those issues are not presented in the court itself and don't become a part of the record. Again, this is something to encourage individuals to come forth in rape cases. So here we are. It breaks it down more. Embarrassment and humiliation overcomes their reluctance to testify, and it's the theory that the victim's prior sexual activity is irrelevant because it says nothing about the victim that was raped at that time. So victims of rape should receive no more scrutiny than other crime victims. It says women not required to resist. That is not an, that question you can't ask that question, and it makes sense. Why are you going to tell a person, oh, you didn't resist, did you? Well, the point of the matter is that they're not required to present that response. No, did I resist? Well, here's the deal. Someone is forcing you and tying you down or having a weapon on you. What are you going to do? They're bigger than you, those kind of things. You are maybe given something to make you drowsy or drunk or something. Anyway, it's against the will of the individual. No. Did you enjoy it? That kind of crazy stuff. No. So rape shield laws there. Get into sodomy, which we don't hear a lot anymore, oral or anal sex between persons, or sex between a person and an animal, bestiality. It can be consensual or unconsensual based upon the individuals. Unconsensual sodomy is a crime and is often charged along with rape, so you don't hear that too much. Consensual sodomy is not a crime, and the Supreme Court has held that states may not prohibit consensual sodomy between same-sex partners. Of course, we understand with the law, with the LGBT and the civil rights laws, and then now the change in marriage, it would be comparable to say that if you were part of the LGBT group, then you could go to jail, and that would violate civil rights laws. And so, no, ain't happening. Sexual offender registration laws originating pretty much from the Megan's Law, which was a young girl who was raped and so forth, and then came up with the right to be able to track those individuals, and registration started. Upon release from prison, offenders have to register with local law enforcement agencies, including their address, and the information is publicly available. We can go to I can go in here to my state police listing, and then I can find out who is a registered sex offender within my community. And, you know, I will say this, that I think that it's very important. People should know who is around them, particularly if they have children. But the point of the matter is this: I remember some years ago in another community I lived in, which was a single-family residential area, beautiful homes. Our home had been built from the ground up in 1999. We left there in 2011. But at any rate, before we left there, our kids would catch the bus on the corner from our house, which was not too far away. We could step out on our porch and we could see the bus stop. At any rate, what we did oftentimes, we would walk to the corner. Well, we discovered that there was a car that was down maybe the next block just a little east of where the bus stop was, and actually where the bus had passed. And there was that car all the time. And so kids, when they would get off of the bus, would also walk in that direction, some of them for the next block over, towards where that car was. But here's my point, is that we complained to the police, and the police had a police officer to be on the corner, not in uniform, just plain clothes, in a regular car driving by. And they checked the plates on that car. Registration was, you guessed it, an individual who was a registered sex offender, and that person was hauled in. But that's the reason for those. Now, the other issue is this, is that as a lawyer, I can tell you that because of the failure to receive adequate treatment while incarcerated, there are many individuals who have illnesses and will be recidivists, and so the public, for the protection of the public, these laws came about and remain in force, such as not being able to go within so many feet of schools or where children are, and, you know, those kinds of things. But anyway, it's for the protection of the public. But the debate goes on and says they're too long, laws are overly inclusive, include too many petty offenses. Now, I agree with that. I agree. For example, it says as peeing in the park, urinating and stuff like that. I agree that that's a situation that really, really, really needs to be fixed. Seriously. I'm not talking about a person who's out there trying to flash and stuff like that. Well, those people are sick anyway, but you know what I'm talking about. But a person who might have a bladder problem or just can't make it, and it happens. Even in their vicinity where they live, they can't make it. The bottom line is that they're not trying to, I've seen people get behind cars and stuff like that. You know, it's happened to all of us. But the point of that is if in some jurisdictions, I have seen people who were convicted and forced to register as sex offenders. That's to me, that's not fair. To me, that's wrong. That's wrong. Okay. So then the other debate is that people are punished on status rather than wrongful acts. And so, anyway, that's the other argument. And then this is Supreme Court held that Alaska state sex offender registration may be applied retrospectively to defendants who were convicted prior to the implementation of the act. Two defendants had challenged the statute on the basis that the statute was punitive in nature, and punitive statutes cannot be applied retrospectively. The court disagreed, said that sex offender registrations are not punitive, but are for the protection of the public. So what does that mean? Is that even if you committed the offense before the Registration Act came into being, and you were actually a sex offender, you then had to register. So some people says that's a ex post facto law, a law after the fact. But that's a punitive law if it's ex post facto, but this is not punitive. This is for the protection of the public. That's what the ruling was in this case. And then it talks about sex offender registration laws, and other instances and things of that nature as well. So, all right. So I'm going to skip over that. Child abuse, actions that physically or mentally, emotionally endanger the welfare of a child. This has increased, and part of the reasons is because there are people who have been placed in a lot of situations where they're under stress and they do things, and then there's times when people just can't handle children. They have children, but they really shouldn't be. We don't want to pass a law saying that your tubes must be tied, or you must find yourself in a situation where you can only have so many kids. We don't want that to happen. That was places like China and Russia and places like that. But anyway, it's gotten to the point to protect the child, assault, battery, neglect. This is in situations where there have been kids who have not been fed, locked up and stuff like that. There's been some really bad situations. Due to age and vulnerability of the child, these are strict liability crimes and primarily misdemeanors. Okay. Spousal abuse. Anyway, this gets into domestic violence issue, physical, emotional, or sexual abuse of one's spouse. And so court issues orders of protections. And you know what, I'll tell you this, orders of protections are good, but they don't completely solve the issue. I told you about the young lady whose ex-boyfriend killed her yesterday. She had an order of protection, but he stalked her and found her. And unfortunately, as I explained to people, the law is only as good as not the enforcement of it, but what people do in terms of respect in terms of it. So, Violent Crime and Law Enforcement Act 1994 involves interstate domestic violence, crossing state lines. Where this person was convicted of kidnapping and interstate domestic violence for assaulting his wife, then drove her around from Virginia to Kentucky until he finally brought her to room. That's where the federal government comes in. Anytime you're dealing with interstate commerce and things of that nature. The abuse of the elderly, same thing. We're again talking about domestic violence, infliction of physical or mental harm on elderly people, oftentimes happens in agencies, nursing care, or caretakers. Most of these are civil proceedings, but Illinois, for example, has criminalized it. And I think it's very good because very vulnerable are the elderly. It is a felony to intentionally or recklessly cause injury to a vulnerable elderly person. Here's an example, and when you read this, you'll say, wow, it makes you upset. Dale and Janice Simonster's uncle was taken to the hospital, and the hospital staff could tell that he had not been fed in a week, covered in urine and feces, and that he had laid in a fetal position that took several weeks, at least 2 weeks. They were convicted of elderly abuse, of felony, those kind of things. So it's very, very serious. But again, it goes back to the domestic violence. I taught that course at the college a few years ago. Looking forward to teaching that again in the future. False imprisonment, it's not necessarily what you might think it is. Unlawful restraining a person. Not all states have statutes that make it a crime. Most states have statutes classifying it as a misdemeanor. Some scenarios are unlawful arrest by police officers, prison warden failing to release inmates. Those are things that are getting to what we call 1981 lawsuits. I teach a course in corrections where individuals say that their civil rights are being violated because they're being held longer, and that they should be released. Storekeeper detains a person with shoplifting, and without a basis, and discovered that that person wasn't in fact shoplifting, that person can come back and argue that was false imprisonment. But it ends up in a lot of civil suits. Overzealous male does not allow the female companion to leave the apartment without yielding to his sexual demands. You could take that even to rape. Kidnapping, forcible abduction, and carrying away a person against that person's will is serious, very serious felony. Simple kidnapping, kidnapping for ransom, asportation, carrying away property of the individual. Federal Kidnapping Act came after the Lindbergh kidnapping, hostage taking, where a baby was taken across state lines. Now, recently you've been hearing some of these kinds of things. There was a young girl that recently was discovered in Florida. Well, she was discovered in, I think, North Carolina, but she's from Florida and was taken 18 years ago from her mother by a person pretending to be a nurse. And she actually took that child and raised that child in North Carolina under another name, another identity and everything. But because of DNA, they were able to track her down and find her. It took 18 years. And so now that particular person who actually raised that child is going to jail. But there are a lot of problems in there that are serious there, as I was discussing this with my wife and a couple other people, is that that child now loves that person because that's who they knew. In fact, one of the issues that came up is that this young lady found out 2 years before the authorities caught up with her and didn't turn her in. But she knew. She found out through some means. The point of the matter is that now that child has some serious issues that she has to deal with. Her parents are entitled to her, and that child's going to have some issues throughout life that are probably never going to go away. It's just really, really tough. She loves the person who kidnapped her because the person didn't abuse her and mistreat her. But that doesn't. And there's some instances where people are kidnapping and they're sexually assaulted. I'm talking about a different situation here, like the one there. Then there was another one that just came up recently, where in a divorce case, where the wife took the child and they found her many years later, and now she's going to jail for that kind of thing. So anyway, it's a crime. It's a crime. Defenses that some people argue is that consent of the victim. It's kind of hard to argue consent when somebody's forcing you to do something. That's kind of oxymoron. Child snatching, we just talked about that, where one parent deliberately retains or conceals a child. That's akin to kidnapping. And so the Uniform Custody and Jurisdiction Act deals with that issue. Parental Kidnapping Prevention Act, designed to prevent jurisdictional conflict over child custody matters, reduces the incentive of parental. So we don't want people to do that kind of thing, taking a child away from their parent, one parent or the other, because they didn't get along. Civil rights offenses themselves, or all rights, are protected by the federal and state constitutions of the various jurisdictions to prevent discrimination on the basis of race, religion, sex, national origin. From injury by public officials, such as law enforcement officers, prosecutors. Now, listen to me. Prosecutors are immune, except if they engage in something that they knowingly committed a violation, or other persons acting under authority of the government, hiding behind their authority, their badge, their position, to violate that person's civil rights offenses. Deprivation of rights under color of law. That's what I was talking about a few minutes ago. When you hear the word color of law, what that simply is saying is that, for example, a police officer is hiding behind their badge and violates that individual because they have an office or position that allows them to do certain things, but it cannot go to the extent where it deprives that person of right to life, liberty, or pursuit of happiness. And often those kinds of cases come out in wrongful death convictions where persons have been shot, and then the police officers are prosecuted, like the Laquan McDonald case that we have in Illinois, and some other cases across the country that you've been hearing about. Okay, Lanier, United States upheld the conviction of this judge. This was a judge who was operating under color of law for treating a woman, for threatening a woman to deny custody because she wouldn't have sex with him. So that's the kind of thing I'm talking about, using your office or position. Hate crimes. It's a sad world we're in that we have people committing crime, period. But then when we elevate it to the aspect where it's based on your race, your ethnicity, your gender or sexual orientation, individuals have a right to live free in those situations. And people who just they will either desecrate property, put stuff on there. You know, there are people who don't agree with people who voted for Trump, for example, will do things to those people like this. It'd be egregious. The most egregious act that I know of happened right here in Illinois, and it was all over the world. It went where this kid who had special needs was befriended by a person and taken to the inner city of Chicago and kept and just abused and beaten. Ridiculous. Those are sick people. And even you discovered, if you paid attention, that those people who participated in that, the relatives or the grandmothers of both of some of those people who were involved in those crimes said, we didn't raise them this way. But it's something that has happened. It's like a cancer here. And, you know, people are free. If I don't agree with you politically, I'm not going to beat you because of it, okay? I'm not going to cuss you out and those kind of things because you have a right to your own position. That's part of our democracy. Anyway, so crimes that were generally considered as not as serious, even as misdemeanors, were elevated to felonies because it reached the hate crime status. And because they were happening so much, and now, like I said, in our time today, it's ridiculous that people are committing these acts against people because of those race, ethnicity, gender, or sexual orientation. Now, a lot of people who are of the LGBT community are subjected to that kind of thing. Whether you agree or not agree, that is not your right to abuse people. People should be left alone to live their lives. Anyway, the Hate Crimes Prevention Act eliminates the requirement that the victim be engaged in a federally protected activity. So anything that person is involved. And most states now have penalties on their books that enhance criminal acts when you're convicted of a hate crime. So your sentence is more severe. So that's it for crimes against persons. Any questions, Eric? We have about, I'd like to take, if it's okay with you, an extra 15 minutes just to go over this next one. You're okay with that? You good with that? Can you handle that? There? Okay. Are you there? I don't see you typing anything. I hope you're there. Okay. All right. So you're okay with that? The answer is yes, with us going a little bit over, because I want to complete this next one, because it's a very, 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 it involves also our assignments as well. Okay. Here we go. Okay, great. Plus the students that are here will benefit a great deal from that. Okay. If you just said that and you couldn't, I would either do one or two things. I'd tell you, I understand you're signing off, and then I'd try to go and complete it, but I want to make sure. So let's talk about property crimes. Property crimes. Now we're talking about the crimes that are involved with some of the things we talked about earlier, larceny, which I told you is now considered as theft. And the history, it said that common law was that depriving owners of their personal property. False pretenses and obtaining money or property through misrepresentation started in 1757. And then embezzlement. Embezzlement, using your position of trust to transfer or convert the money for your own gain. Prosecutors have had to prove that the accused intended to defraud the victim. Also receiving stolen property. It's one of those. The infamous people had stuff, and then they said, well, you know, there came a term to it, it fell off the truck. Well, that became a term that people began to understand. What that really meant is that those were hot goods. You know, other people come up on the streets. This is too funny what I'm about to tell you. Is that they come up on the streets and they say, hey, I got these watches, man. You know, they said, and they lead you to believe that they got to get rid of them because, you know, they're really, you know, hot. So a guy walked up to me and he gave me this watch, and he says, man, he said, this is a Rolex. So I said, yeah, man. I said, no, I don't deal in that. He said, no, you got to look at it. So I looked at it. So I said to him, hey, there's no D in Rolex. There's no Rolex. What it was, it wasn't hot at all. It was some knockoff stuff. And if you were gullible enough to try to think you're getting a deal, you got suckered into it. So what's the best policy? Don't buy stuff like that, okay? All right. So you run into problems. So having to give you a warranty with it, not going to happen. So anyway, it's not good. It's illegal. You can go to jail for that. Okay. Modern approach to theft offenses includes, as I said, larceny, theft of vehicles, shoplifting, looting, carjacking, and so forth. Everybody knows about carjacking. I remember years ago we didn't have that term, but you know what carjacking is. Shoplifting, extortion. But anyway, the federal government, 18 United States Code. Now, I wanted to tell you this so that you will be aware that if you want to know where all the federal criminal law is, you look under the United States Code and Section 18. This is where all your crimes are located on the federal level. And this, when you see the A annotated, means there are cases that are under this particular section of that criminal code for the federal government that elaborates on cases or decisions or rulings that fell up under this particular section of the law. So in 641, places crimes so kindred as belonging to one category: embezzlement, theft, receiving stolen goods. Okay, hot stuff. And oftentimes the reason why they would fit in is because those things were actually part of interstate commerce and were traveling on. We just had an issue again in our area here on the news that that trains were coming through, and they would end up stopping sometimes and end up overnight, and they contained guns. And these were guns that were being shipped to other parts of the country, not necessarily military, but people were breaking in and getting those, and those guns ended up on the streets. And then there's 659, provides penalties for embezzling or unlawfully taking the contents of any vehicle moving in interstate commerce, like what I just said, the trains, the planes, the boats, and so forth. Okay. And then this is just a chart, and I'm not going to go over this. It shows you what larceny turned into, and I said already, it turns into theft. And so early terms, these all have been broken down into all of these things that are taking place right now. You can look at that at your leisure. Now, The modern approach to theft offenses. All states now include tangible and intangible property, such as copyright, patents, ideas, and things of that nature. Newer statutes include other crimes besides theft and impose penalties based on the amount and character. So the greater the value of the property, the more likely it would be a felony or you receive more time. Grand theft, and like I said, that's determined by the amount or the value of the property is the most serious. It's kind of like fitting with what I said earlier that misdemeanors are crimes that are under a year. Well, that's because, let's say, for example, if you stole a loaf of bread or you stole, you know, something like that, then, or gum or something from a store, maybe even some clothing, but it's not like, you know, you got some Louis Vuittons and other modern day stuff. You can tell I'm ancient for Louis Vuitton. People say nobody steals Louis Vuitton anymore. They do more knockoffs. But anyway, you know what I'm talking about. Some of these other names that Coors do. I don't know. Not the beer people, but Michael Coors, right? Thanks. My wife just kind of reminded me of that. Petty theft is a serious misdemeanor. So, with intent to deprive the person, willful desire to take goods or services from another without permission or authority of another. Okay. Embezzlement. Now here we go. Here we go. I taught business ethics before I really started teaching criminal justice. Even though I was teaching criminal justice, they loaned me out to teach ethics, because I teach ethics in all areas, business, in medicine, and criminal justice. But this infamous Madoff case, which they ended up making into a movie, in which this guy ran a Ponzi scheme. Now, what a Ponzi scheme is something that leads you to believe that there's some substance behind what you put your money in, but in reality, the person who is behind it knows that it doesn't even exist. Excuse me. It's like getting a deed to property in Florida, and in Florida, where it's a swampland, and making you think there's a resort being developed. Well, that's a Ponzi scheme. Embezzling money from people in the 70s, $18 billion. Among the investors were many middle-class people who lost their entire savings. Pretty bad. And so Bernard Madoff was convicted in 2009 of 11 federal felonies and sentenced to 150 years in prison. And so he's going to be in there a while. Excuse me a minute. So anyway, so embezzlement is pretty serious. Then we get into another crime, Enron, as you're familiar with that. That was another kind of thing, but that wasn't a Ponzi scheme. That was an act of deception of the people that they increased the value of the stock more than what it was to get people to invest. And then many people lost a lot of money, and to this day, what's the guy's name? Jeffrey Skilling, who is a brother of one of the well-known weathermen here in Chicago at WGN, Tom Skilling, and were raised actually in Aurora, Illinois, not too far from where I'm at now, is now in prison for a long time for that. The other guy who was involved was a guy by the name of Ken Lay. He committed suicide because he knew inevitably that's where he was going. So anyway, that's another one of those. So now robbery. Now, here we go. Pay close attention, because now we're getting into the assignments here. Crime of taking money or property from a person against that person's will by means of force or intimidation. That's it. Taking money or property from a person against that person's will by means of force or intimidation. That's pretty much how it is applied across the country. The key aspect is it says the force or violence have to happen before or at the same time as the taking of the property. Okay? And under common law, robbery was an aggravated form of larceny, where the taking was accomplished by force or violence. So it's kind of the same thing now. But robbery is more serious. Okay? Offense against a person, it usually involves assault or battery. So, if a person is present and they happen to see a person taking something that's theirs, and that person is not, I mean, they might be fearful that they came upon that person that's farther, they come upon, but unless that at the same time that the person was taken, let's say they're running away with it, that's not going to be robbery. That's going to be theft. Okay, there we go. Robbery includes bank robbery, and you know that's a federal law. And then you know too, robbing these FedEx, UPS, and now, I don't know about in your area, but in our area here, we're having a rash of people that are postal carriers, United States postal carriers, who are being robbed at gunpoint, and those kind of things. Feds are involved in that as well. State laws have codified the common law, and other states classify robbery according to a degree. Aggravated robbery is the highest level. The United States Supreme Court held that an unloaded gun is a dangerous weapon. No, but the gun was unloaded. Well, here's the deal. Display of the gun itself instead of sparing the average citizen. As a consequence, it creates an immediate danger that violence will ensue. It says McLaughlin and a companion robbed a bank and didn't have any loaded guns. They argued that the guns were unloaded but not a dangerous weapon. Let me give you an example of a situation that I was placed in years and years ago when I was a police officer. Now, I didn't ever wear a uniform because I was at the same time working as a special officer, but I had to go get the training and all of that. And then I wore a suit and I had a shoulder holster, and I had a Glock and a 38. But anyway, I didn't wear them both. So I had usually sometimes I alternate between my Glock and, but anyway, I had a shoulder holster and I'd wear it under my suit. So I remember a day when I came out of the village hall in the town that I was the village prosecutor, part-time police officer, and then I don't think I had become the internal affairs investigator yet, but I was heading in that direction. But at any rate, what happened is that this young man approached me, and he saw me, and he says, give me your money. So I told him, I said, okay, let me get it. I says, inside my jacket, my wallet is carried down in there. So I'm reaching down, and while that I'm talking to him, keeping my eyes on him, keeping him occupied with a conversation we're having. And then all of a sudden, I come up with my gun. I had a Glock. I remember I had the Glock that day. And I pulled that gun on him. And I said, okay, drop your weapon. And he dropped his gun. He was a teenager. And I said, kick it over. So he kicked it over to me. The gun was a toy. I told him I would have been justified in shooting him, and that it would have been his death, and then I would have used the necessary force because he pulled this gun. It is not my call to say, oh, yeah, that looked like a toy gun. No. I felt like I was in danger, but I talked to him and got it. Turned out I knew his mother, and long story short is he got his butt beat because we took him in, and then his mom came to the station. She had to leave her job early, and I told him he's in the lockup. His mom went in the lockup, and she was inflicting some harm on him that probably the police officer down there would have considered as excessive force. And long story short is the young man ended up apologizing. So there were no charges. I refused to press charges against him. So that young man, his mother said she got to get him out of the area. He's trying to do this because he's trying to impress some people with a gang. Sent him down south to, I think, Georgia in that area. Anyway, long story short, the young man ended up down there, went to school, graduated, became involved in the church. Last word I'd heard, this was years and years ago, a deacon, and had a family. So it ended up well. But it could have been bad for him because I could have blown him away. I could have emptied my clip, in him. But the point of the matter is that here's the point, is that an unloaded gun or a toy gun is the same, okay? Carjacking. We already know about that, so I'm not going to spend a lot of time taking up a vehicle by force of intimidation from someone. And then, too, that if a car, what I don't understand is people leaving their keys in their car and running. Sometimes I leave the key in my car in my driveway, and I don't even like that. But there are people who go to the gas station, and they get out and they'll go inside, make change and stuff, or do whatever they're doing, and leave their car running, or leave the keys in the ignition. I have a habit, my wife will tell you, even if they're in the car, I still grab them. Well, we're in here. I said, I know, it's a habit because it's something that I don't do. But I'm trying to tell you, there are many people, many times. And then there are people who pump their gas. They get out to pump their gas. They leave their key in. They walk around the other side to pump the gas. And while they're pumping the gas, some person comes to the other side, opens the door, turns it on, and drives away with the car. That's jacking, but it's crazy. You got to be smart. You got to be smart. Anyway, the Anti-Car Theft Act of 1992 makes it a crime to take a car. And then amended by 18 U.S.C. It says carjacking or attempted carjacking and so forth. So anyway, the bottom line is taking someone's car from them. Okay, and then here we go again talking about carjacking, so I'm not going to get into that. Okay, so robbery, we already talked about that. Taking money or property against that person's will by threat of force or intimidation. Taken by the threat of force without consent. Felonious taking. Taking the property off the victim, person, or immediate presence and requires general intent. Extortion, on the other hand, obtaining money or property by threats of force or inducement of fear, also called blackmail, taken by the threat of force with consent. Property does not have to be taken from the victim's person or immediate presence. That's what I'm trying. That's the difference. That's the difference. This is it. It has to be off of the person. This is not from the person's presence. Okay. It requires specific intent. Forgery, that is taking a document, of course, and changing it. Like, for example, taking your $30 and turning it into $300, or altering the grades on a college transcript. Let's say, for example, if you got a transcript. Now it's harder to do that because if you get a transcript, usually it's sent directly to the institution, or when I got ready to apply for a job at the college, I had to get my law school transcripts and my undergrad, my bachelor's degree transcript from Roosevelt. But what I did was I went and got them. But what they did was I paid and they gave me the transcripts, but they had a seal on it. And it's kind of like, those Oscars or Grammys and so forth. If that seal was broken, the integrity of what was in there would, no longer be considered as good. And so that's the same thing then. So when I turned it over to the person who interviewed me, I said, I have them right here. And they took them and accepted them based upon fact that it had the Northwestern seal that wasn't opened or nothing like that. And then, now there are some people, somebody says, you could steam them and then close them. Well, that's crazy. But that right there shows you right away that you don't want to hire that person, or either because that person's already showing a lack of integrity or ethics. Anyway, under federal law, the prosecution has to prove the intent to pass bad money. Also, forgery and stuff like that. You know it is illegal to make a copy of money, okay, on your Xerox machines. Counterfeiting, making an intimation of something with deceptive disease, making, as I said, imitation coins and currency, those kind of things. Now, here's an interesting one here. I wasn't going to read this, but I always find this very interesting. Here's something that's very interesting. Hitler's diaries. In 1983, a West German magazine, Stern, made the shocking announcement they had 62 handwritten diaries from Hitler. Now, here's the tip-off. The contents of the diaries challenged historical views concerning Hitler's characters and action, presented him as a more amicable person than he had been documented. In other words, he wasn't as bad as they said he was. Many who had known Hitler personally were shocked because they had experienced firsthand atrocities committed by him, so they weren't buying it. So here's what happened. After a few weeks, it was discovered that the diaries were forgeries, which the people there knew, but here's what happened. Even though Stern had asked experts to verify the authenticity of the documents, unfortunately, the experts compared the diaries to original documents that were also forged by the same person. So the bottom line is that didn't prove authenticity, okay? Forged utterings such as a check and so forth, I already talked about that. That's a felony. Worthless check, writing a check, is not any good. And oftentimes there are state jurisdictional requirements that require you you have a misdemeanor case, and there's a fee oftentimes that goes with this. But if it's a stolen check, it's not going to be the same. But tells customers who write those checks, this is worthless check. It's not the same as someone stealing your check, where you know that you didn't have those funds in the bank. And check bounces. Okay. Now, my all-time favorite here. Again, I already talked to you about theft. I talked to you about robbery. Now, let's talk about burglary. Now, burglary, as I said earlier, was breaking and entering the dwelling of another with intent to commit a theft or larceny in the nighttime. And I said already that that's been done away with. So here's the way burglary is looked at now. The person is guilty of burglary regardless of lawful entry of the dwelling. For example, I had this happen too. Intentionally remaining in a department store with an intent to commit an offense after the store closed for the day. I had a young man one time who had this brilliant idea that he would stay in this Kmart store, and he would go in the bathroom, and he would put his feet up on the toilet and, stay in there. And then when, the store was closed and they checked the bathroom, they didn't check the stall itself. They ended up, the store was closed. He changes into some black clothes, ninja type clothes. So what he does, he comes out, and the reason I'm laughing is because of how it's going to end up. Is that this young man comes out, and he announces, that he's taking this, and he's taking that. So he started taking some things from the store and so forth. And then he got ready to leave, and they started going after him. When he realized he couldn't get out the door. So what he did was he jumped through the window, shattered the window, but it knocked him out, and he was arrested unconscious on the ground in front of the store. His mother hired me as his attorney. I tried to argue insanity, but he wasn't considered insane, but, just some stupid stuff. And so, anyway, he had seen something like that in a movie or something, he said, and he tried it. And obviously, it didn't work. So I negotiated a plea for him. But anyway, the bottom line is that was just dumb. It cost his mother about $5,000 that I made to represent him, but it was crazy. But anyway, That's burglary. Now, let's talk about home invasion. Home invasion is armed with a dangerous weapon or persons are present in the home at the time of the break-in. That's home invasion. Then we talk about possession of burglar tools. If the possessor has the intent to use the tools for burglary, so whatever those tools are, screwdrivers, a knife, even some kinds of keys. Now, before I leave burglary, I'm going to go back. Let's go back. There we go. Okay, now, breaking and entering the dwelling of another. Okay? And the point of the matter is that what happens in this situation is this. Here's the deal. Some people say, okay, this person didn't physically go in the house, but they opened the window and they reached inside the window and grabbed something out of the house. That is burglary. And the reason is because you're breaking and entering of another with intent to commit a felony, a theft. And when we call it breaking the plane, the curtilage, the area of that person, and taking it, that's considered as burglary. Okay? Now, there's arguments, too, that burglary takes place if, for example, on my property you take my swings or you take something off of my property or something like that. For Christmas, we had in the front yard some of those star shower lights. You know what I'm talking about, that you put those in the ground and you plug them up, and then the lights go on, show on the house like it looks like I got a bunch of lights hung up on the house. Well, somebody took it. We had two of them. Somebody took one of them. Well, it could be argued because it was on our property that was burglary. But the clearest case is that if a person, for example, opens the door and sees something and takes it, and it's inside my house, they get it. Now, there's a question. If I have a package delivered to my house and it is inside my door or on my porch, is that burglary? That's arguable. But it is already established and clear that if that person did cross the line with any parts of their body or even an extension of their body, had a stick or something, and they took something out, that's burglary, period. Okay. And so that might answer some of the concerns. And you'll see some cases like that, too, if you do some research in dealing with your discussion post. Arson, intentionally burning someone else's home or building, now commonly extended to vehicles and structures. Prosecution just has to prove intentional and criminal act. It can be a misdemeanor or felony. Burning property with intent to defraud an insurance company, that's another. You know what I'm talking about there. Okay. Got a couple more to go. And then here's an example of a serial arsonist, a person who's a fire captain and arson investigator, set a series of fires around Los Angeles. The fires always start around highways and near arson investigation conventions. He was arrested after police matched a fingerprint on a time-delay device, and he was sentenced to a life in prison. Why was he sentenced to life in prison? Because of his position that he was in. That's one reason. Malicious mischief, vandalism, simple vandalism, willful destruction of property of another, graffiti, interruption or impairment of transportation, supply of water or gas. What are we talking about, supply of water or gas? Your water or gas is turned off, and then what you do is you connect it again without paying the bill, without them coming to connect it. That's what they're talking about. But it's a form of theft. Defenses to property crimes. These are some defenses that people use. Unintentionally takes the wrong jacket from an airport. That could happen. Or the wrong luggage. That can happen too. Mistake of law. Concerning ownership rights. Well, that's a debate about title. and who owns the property and that kind of thing. Has to be some reasonable basis though for that. Lack of intent. Well, it has to be established under all the circumstances that you intended to deprive the person permanently of the property. There's arguments, for example, that people who rent cars and keep them longer, that consider this theft, generally they don't intend to do so. But again, most of the time what happens is that there's additional charges that accrue. Alibi, I wasn't there. I was insane, forget that. Duress, not very popular. Intoxicated, depends on what kind of intoxication we're talking about, voluntary or involuntary, okay? And that's it for tonight. Any questions, Eric? Okay. All right, so at this time, oh, you're welcome. So I'm going to end tonight. I've given you some stuff that will help you with your assignments for the week, your written assignment, as well as your discussion post that's due 11:59 p.m. Central Standard, which is about an hour and 45 minutes from now if you haven't already done so. All right, so with that, I'm going to say good night. Thank you for coming out, Eric. I appreciate you coming out. Okay, so I'm going to end the meeting, say good night. Thanks.